Good evening, everyone. This is AROOP here. I have been in this profession for about 5 years now, and I graduated from School of Law, Christ University. So in total, I think I've been in law for 10 years. And so far, banking and finance, although we had like a subject in fourth year, but whatever they taught us in banking finance, I don't think most of it is not applicable in real life practice. But then, obviously, I'm someone who also believes that whatever was taught was important because that did give me a basis of, that did lay down a foundation of what I am doing right now. So, yes, so we are just here to tell you how the professional side of things look like, apart from the academic side, because I think academic side, if you are all in your fourth or fifth year, I'm sure you would have studied your banking finance subjects as well.
Also, I would request all the students, if you have any questions or anything, please note it down while the presentation is on. At the end of the session, whatever questions you have or whatever doubt you have or whatever way forward you require, we would be happy to take it up one by one. Go to the next one. So quickly, I will let you know, introduction is done. The overview of the presentation is, built into 5 parts. One is we are going to explain to you what are the type of financing. Okay, in general, how the type of financings are and what we generally in as a banking finance lawyer deal with types of financing. Second is when there is a financing, the lender would request some sort of security. Just to give you an example, when you go for a home loan, you mortgage your house, correct? When you go for some personal loan, you may be giving your FD rights or some general rights to secure that loan. So therefore, in any financing transaction, security is very important aspect. So we are going to discuss the security interest aspect related to banking finance type of financing. Thirdly, we will be discussing that what all documents typically are involved in this type of financing. Okay. And then we will discuss about the authorizations and typically what all things we generally look at as a banking finance lawyer when some financing transaction happens. And lastly, we will discuss about the laws which surrounds the banking finance. So banking finance is a very vast subject and there are multiple laws related to it. So there could be a financing of 1 lakh rupees, there could be financing of multi-billion dollar of rupees. For each type of financing, there are different sort of issues, there are different sort of legal complications are there. We as a banking finance lawyer, how we look at it, we are going to discuss on the same. So basically there are Arup, just go to the next slide. Yeah, basically there are 2 types of financing. Okay, one is fund based and non-fund based financing. Now question would be, what is fund based and what is non-fund based? Fund based means where some sort of tangible fund related thing are involved, like rupee term loan or a sort of any sort of a loan where basically there is a transaction in a where there is a involvement of fund. Non-fund based is also a banking finance transaction, but where typically there is no direct fund requirement. It is by way of some instrument like letter of credit, bank guarantee, bank guarantees and letter of credit. These are basically some payment mechanics are there, but those happens on certain contingent event. Arup, you would like to explain further on this fund base and non-fund base?
Yes, thank you, ABIR. So to just simply put out there, the difference between fund-based financing and non-fund-based financing is, while you all must be conversant with the fact of all the loans whereby you actually get money. So in most of the day-to-day loans that you can think about, like for instance, if you're purchasing a mobile and you want to take a loan on it, or you're purchasing a car or a house, so all of those kinds of loans would be typically fund-based financing, whereby the bank will have to transfer some fund in form of money to some other account for utilization of the loan. But then for a non-fund based facility, the bank who is actually giving this facility does not transfer any kind of funds. They would be giving forth, they will give forth a particular instrument which can be capitalized after happening of a particular event. Like for instance, if a bank guarantee is being issued for 20 crores. So in such an instance, whoever is the beneficiary of the bank guarantee, only upon happening of certain events will notify the bank, and only in such event will the bank actually give away that will disburse the bank guarantee for the benefit of the beneficiary. So, like the natural question which would flow is, why would you have any of these facilities, right? So, the simple answer to this is most of you would also be conversant with the fact that, like, let's just say that you want to take up a McDonald's franchisee. So, for a McDonald's franchisee, also, they have a security deposit concept, right? Where they will take about 2-3 crores as security deposit. So as an investor who wants to get into this business, you wouldn't want to typically have 2-3 crores rupees amount of money lying there idle in an account, because it's not going to be interest bearing. It will not benefit you in any manner. So instead of that, what you do is you go to a bank and you tell them that, why don't you issue a bank guarantee on my behalf for 2-3 crores, and I will pay you commission for that. As long as, but then if McDonald's as an entity invokes that bank guarantee, then I will pay you that 2-3 crores back. But then what happens in this particular transaction is the 2-3 crores of the investor is actually not getting tied in. So the investor can actually use that 2-3 crores outside of his or her business and things like that. So in this kind of transaction, although a bank guarantee is issued, no particular amount is transferred to the beneficiary, right? So which is why it becomes a non-fund based facility. And you have multiple instruments under non-fund based facility. Bank guarantee is just one of them.
Correct.
So
thanks, AROOP. So these are the two things. Like, one is, as we explained, fund-based financing. Another is non-fund-based financing. There are different type of financing, like structured financing and different sort of a thing. But for now, I think for your understanding, these are the two basic things: fund-based and non-fund-based. Now, next comes to the origin of financing. Now, within India, whatever, suppose you go to SBI or you go to IDBI, you take a loan as a borrower. So that is domestic funding. Okay. Basically, there is one resident Indian taking loan from another resident bank or non-banking financial institution. There is another type of financing which is called external commercial borrowing, or or funds coming from outside India. So there are banks outside India, they give also loan for certain purposes, or there are some requirement they have, borrower would have in India, and if they meet certain regulatory compliances, then the borrower in India can get loan from outside. Now the question would be, why someone would get loan from outside when there are so many banks in India, so many financial institutions are there in India? Because this outside borrowing sometimes becomes cheaper to the borrower than taking a domestic loan. That's why there are instances where the borrower goes out of the country and asks outside lenders to provide loan to them. So there is another form of funding is there, that is called overseas direct investment. But that is something investment. In terms of loan transaction, there are domestic loan and external commercial borrowing loans, and there are various rules and regulations surrounding to it. When we go to the fifth slide, we will explain to you that what all rules, law, regulations are there decoding this sort of financing. AROOP, move to the next slide. Yeah. Please start with the security thing, AROOP. Then I will pitch in.
Yes, thank you, Abhi. So basically, this is also something that you would have heard on a day-to-day basis, that whenever you take a loan, the bank would take some sort of a security or a collateral, because sometimes even for the banks to invest so much money in form of a loan in a particular individual or a company, they also need to have some comfort, and they need to also have like a safety net, because it's a huge risk for the banks to take. So whenever they gave a loan, uh, you obviously have unsecured loans where the lenders will give loans without any security. But then most of the times the lenders would also prefer to give loans where they have a security. So security as a concept is a very simple concept, that you basically create a security interest by way of pledge or hypothecation or mortgage on certain assets, which the lender can go ahead and liquidate, like which is basically just selling off, in case the loan becomes a bad loan. So predominantly property wise, like distinction wise, we can distinguish properties into two different parts, right? Which is, one is immovable property and the second is movable property. You obviously have this distinction between tangible and intangible property, but for the purposes of this presentation, we would be dealing with intangible assets, which is intellectual property rights, in the movable property, because most of your, actually all of your Indian legislations, they classify intellectual property rights as movable property, including shares, as per your Companies Act 2013, is a movable property. So first, the most common form of security which you would see on a day-to-day basis whenever you buy a flat or purchase a house or anything is immovable property, which is your landed property or a building or anything which is considered to be an immovable property in terms of your Transfer of Property Act. So security interest on immovable property can be created by way of 5 different types of mortgages, which is covered in your Section 58 of Transfer of Property Act. But because of the legislations and the practice over the years, Indian banks and even foreign lenders have come down to only two major forms of creation of mortgage uh, on immovable property. That's also predominantly because of the taxation structure in the country, that they prefer for retail customers like you and I, they prefer deposit of title deeds, and for like a corporate client, they prefer something of a registered mortgage. So I'll just quickly tell you the difference uh, uh, between creation of mortgage by way of deposit of title deeds and the registered mortgage. So deposit of title deeds, as the name suggests, is a very simple form of creation of mortgage, where the owner of the property would go ahead and deposit the title deeds with the lender with an intention to create mortgage. And there is no per se formality pursuant to this, but then there are states like Tamil Nadu, Odisha, Maharashtra, not Maharashtra, Gujarat,
Gujarat.
where you have to register all of these mortgages with the sub-registrar of assurances. Generally, whenever you buy a property or you sell a property, you go to the sub-registrar's office, right? It's the same office which should also record a mortgage. So, but because deposit of title deeds is not something which is covered by all the states, so most of the states you don't have a registration requirement. But then with a registered mortgage, which the name itself suggests that it has to compulsorily be registered with the sub-registrar of assurances, you execute a document called indenture of mortgage, where you basically put down your intention. The borrower puts down its intention of mortgage, creation of mortgage of property, without giving away the possession. Because once you give away the possession, it becomes a different kind of a mortgage, and the stamp duty implication on that is extremely high. So
I will
generally,
just add something on this. Please remember, mortgage, there are two types. One is with possession, another is without possession. When it is with possession, that means possession is already transferred. Because in English mortgage, you all would have read it, it's an absolute transfer. But there is a concept called without possession. Now you would be thinking while reading this, why without possession? Why someone would create a mortgage and don't give a possession? Now I'll give you a classic example, which Amit and I would deal with day in day out. Suppose a borrower is setting up a project, a power plant, correct? Now power plant would be on a land, correct? That land, when bank is financing, bank would ask for that land to be mortgaged to them. Now, if the possession is transferred to the bank, how someone will execute the project? That's why the concept without possession has come. Even though mortgage would be created, but it would be transferred, absolute transfer to happen without possession. Possession would be given when there would be some sort of an event of default situation would occur. So technically, if you see, uh, movable and immovable would be sort of a similar sort of a nature when mortgage would happen without possession, because in case of hypothecation also, you basically hypothecate all your movable asset without giving the possession, because movable asset would crystallize on in case of an event of default. Therefore, this is an important distinction you must remember, that mortgage with possession, without possession, and there are different stamp duty implications towards that. Okay, go ahead, Aru.
Yes. So that's on all immovable property. Like Abir had mentioned, it just becomes like for a project financing, it becomes difficult for giving away the possession as well. Otherwise, the whole project financing itself would fail because the borrower will not be able to undertake the project on that land. So just moving on to movable properties, like Abir has already mentioned, for like we have it for immovable property, you can create security interest on movable properties with giving possession or without giving possession. So when you do it without giving possession, it's called a hypothecation. And when you give it, when a security interest is created by way of giving possession, that is called a pledge. So pledge as a concept has been covered under your Indian Contracts Act as a special contract, I think after section 126 of the Indian Contracts Act. And hypothecation has not specifically been dealt under the Indian Contracts Act, but then there are mentions of it in the CIIA Act. So, like I said, hypothecation is for movable property without giving possession. So, in this, you would typically see security interest being created on both tangible and intangible properties, which is intellectual property rights. And for this, you obviously have to make some sort of a registration. If it's a company, you will have to do it with the registrar of companies. And if it's not a company, and for companies included, you make a registration with the CIIA.
Just one, classic example I will give you all. When you go on the road, sometimes you would see some car, with, or some buses. You would see this bus or this car is hypothecated to so and so bank. So basically, the owner of the car, the owner of the bus would have taken a loan, and they would have hypothecated that car or bus to that bank. In case they fail to make payment to the bank will come and take possession of that property. Because it is movable property, that's why it is hypothecated. Had it been fixed, it would have been an immovable property. So that distinction is also important, you being a lawyer, that how you're making a distinction of any asset and how you are securing that asset. Remember this. It is very important for you being a lawyer to identify the distinction between movable and immovable asset, and how you are going to create a security, and how you are going to perfect a security. As Aroop said, CIIA, you may not be aware of CIIA. CIIA is basically sort of a filing which has to be done in the central registry post creation of security with respect to mortgage, immovable property, and hypothecation. There is no CIIA thing for pledge as of now. Now, why CIIA is important? Because under SARFAESI Act, if bank has to take sort of a SARFAESI action under 26D, then the CIIA filing is must. Okay. So these are very minute details. We as a banking finance lawyer have to be mindful about it. Tomorrow it may happen you are working within bank as a bank employee, bank legal officer, or you may be defending a bank in terms of enforcement of some security, or you are advising them to do some documentation. So these things will become very handy for you, because this is anyway applicable pan India. Go ahead, Arup.
Yes. So I'll just quickly. So what in form of intangible property, which is intellectual property rights, currently the Indian legislations have not been amended enough to take care of security interest, which is being created on intellectual property rights. But then the copyright law does include a provision where you're required to record all assignments of intellectual property rights. But then because generally for hypothecation, we create a security interest for intellectual property rights by way of hypothecation, which is not strictly an assignment of sorts, which is why we don't typically do a registration under your Copyright Act. But then if it is an assignment, you will also have to make a recording of that uh, in your registrar of copyright. And just a quick distinction between creation of security interest on movable properties with possession. You do it for all kind of receivables and fixed assets like a chair, table, car, bus, all of that. You do it by way of a hypothecation, which is without possession because the owner needs to continue using that particular asset. But you have things like shares for which you do a pledge where you give away the possession of your shares, the movable property of shares, or any other form of securities that the lender would keep possession of those movable properties.
This is typically called a floating charge. That means today, suppose you have, done a hypothecation of your movable assets. Movable assets keep on increasing or decreasing. But at the time of enforcement, whatever movable assets you would have in your possession, bank would basically convert that floating into a fixed charge and take over the asset. So these concepts are called floating charge and a fixed charge. Remember this. Okay. Now, see, when the financing happens, there are multiple sort of documentation happens. Okay. So for bank, how it works, I will simply tell you, how it works for bank. Banks get deposits. So you, your family, my family, there are multiple people who go and put deposit into bank, correct? You do fixed deposit and you get an interest on it. Bank gives you some 6%, 7% interest on your fixed deposit. But then bank will have to put that money somewhere from where they'll have to earn that deposit, correct? So as to when the repayment would come to you after 1 year or 2 year, then they will be able to pay you your principal along with the interest. So what bank does typically, bank utilizes that fund into various activities where bank would earn the money, higher interest rate. So what happens is a cycle. You put in the deposit, those public deposit bank would utilize into various fundings. Against that funding, bank would earn interest. Bank would utilize that interest to repay you along with your deposit. So this is called a cycle. Okay. Now in this cycle, as Arup correctly pointed out, you need to have a security. Tomorrow, if bank is funding, bank is under tremendous scrutiny that they are using the public deposit money. Okay. Then they'll have to give back that money to the public as and when there is a requirement to give it back. So therefore, there is a security structure when bank is funding to someone else that public deposit. Similarly, for this deposit and this utilization, there are multiple RBI circulars, which we will be discussing in the next slide, and we will take you through. Right now, when bank would enter into any sort of documentation with the borrower, they would try and protect their interest, correct, and try to recover the money. So because of which there is a basically sort of origination of these documents, which is called facility agreement. So what is typically a facility agreement? Facility agreement would typically deal the relationship between the borrower and between the lender. What are the interest rate? What are the terms of the facility? What are the covenants the company would give? So when borrower is taking the loan, lender has to be sure that there are no sort of default borrower is into. There are no liquidation processes. Borrower is giving proper representation. What are the event of default? in case where bank would have the right to recover the loan. So these are the basic things which are covered under the facility agreement. Then there is another agreement which is not coming, is called a security trustee agreement. When there is a multiple banking arrangement where there is a consortium of bank, there is a requirement that the security to be held by someone else as a trustee of the bank. So that is called a security trustee, and for which there is a security trustee agreement which typically banks enter into an appointed trustee to act for their benefit. Then AROOP has already explained indenture of mortgage, and memorandum of entry and declaration is nothing but a deposit of title deeds. Then pledge and power of attorney also AROOP has explained. He will explain in detail. Then there is a concept called guarantee. So what is the concept of guarantee? You would have all read in your contract act subject, correct? There it's a basically three parties. There is a borrower, there is a surety, and there is another beneficiary. So there is a deed of guarantee which can be by way of a corporate guarantee or by way of some personal guarantee. So for company borrowing, there are parent company who would give the corporate guarantee to secure the loan availed by its subsidiary or its group company. Similarly, there are personal promoter, who would give the personal guarantee for this. And there are various type of sponsor undertaking. Now, Arup, one by one, you please take them through very briefly, that I have already detailed the facility agreement in deed of hypothecation and other documents, which are the typical thing they as a lawyer should be looking at.
Yes, yes, thank you, Abhi. So, facility agreement, as Abhi has already explained, that's going to be the mother document of everyone, because that's going to be governing all the relationships between the lenders and the borrower. So, all of the rights of the lenders would originate from the facility agreement, and you will have all kinds of security which will be created, or contractual comfort which will be given to the lenders by way of the following documents. So, like I've mentioned in the previous slide, deed of hypothecation is a document which is executed for creation of security interest over movable properties without possession. So, in a deed of hypothecation, if you're ever having an opportunity to review a deed of hypothecation, the most critical thing to see is the charging provision, where you basically put down what is the description of the security that you're taking for this particular loan. And then there is indenture of mortgage. Indenture of mortgage is a document which is executed for creation of security interest over immovable properties without possession, and which needs to be registered, which needs to compulsorily be registered with the sub-registrar of assurance of the relevant area. This is again to create security interest on immovable property. Then is memorandum of entry and declaration. This is the second type of mortgage that I was just mentioning about in the previous slide, where this is generally given out for retail clients, where the owner of the land will basically just go to the offices of the lender or wherever this is happening and deposit the title deeds for with an intention to create mortgage. So the memorandum of entry itself, that's a recording by the lender that so and so person had visited our office on this particular date and had deposited the title deeds. And declaration is where the intention for creation of mortgage is clearly spelled out, and the person is basically affirming in front of a notary that this deposit of title deeds is being made with an intention to create mortgage. This becomes a very essential practice because of two reasons. One, because in your Transfer of Property Act, Section 58, whenever there is a creation of mortgage by way of deposit of title deeds, there are two components which are required to be met. One is the very act of deposit of title deeds. Second, that it has to be done with an intention to create mortgage. So when I say that, the first portion where the deposit of title deeds needs to happen, that gets covered in your memorandum of entry. And the second portion where the intention has to come out, that happens in your declaration. So that's how both of these documents work in tandem. And the intention to intention to create mortgage also becomes essential is because you might give your documents to someone just for safe custody, or you want that person to make any reference. Just because you have made any deposit of title deeds with anyone does not automatically become a mortgage in favor of that person, which is why this declaration becomes essential, and which is why for creation of security interest by through this means, you need to have two documents in place necessarily. Then is pledge agreement. Pledge agreement is again something which is executed for creation of security interest over movable properties, but with giving possession. So in a pledge, like for instance, pledge in Indian financing scenario has been implemented only for shares and sometimes even securities. So shares is something previously we used to have physical share certificate. So back in the day when pledge was being created on physical share certificate, the owner of the physical share certificate could literally have to go to the office of the lenders and have to give away the possession of those share of certificates, and will give the possession of those certificates to the lender. But because everything has been dematerialized right now, and you have demat accounts for this, for storing all of your shares these days, but pledge agreement works in a way where if you are executing a pledge agreement for transferring a particular share for creation of security interest, so the pledger who basically is giving the security, from their account, the shares would travel to a pledged account, which will be the lender's account, and it will stay there. So in this particular instance where things have been dematerialized also, pledge is where the possession is actually given out from the borrower to the lender or the security creator. So that is on pledge, but then you sometimes couple it with a power of attorney. Actually, most of the times you do couple it with a power of attorney, that in case any default happens, then the lender will be able to step into the shoes of the borrower or the security provider and sell these shares. So that's how a pledge agreement and power of attorney works for creation of security of interest over movable properties without giving possession. Sorry, with giving to possession.
Just simple
Deed of,
thing. See how you can see you have read the bailment, correct, in the Contract Act, but how in actual this is being implemented, that is through pledge agreement and power of attorney. So this is the difference. See, when you are studying law, there is one thing that basics you will study, but when you enter into the practice, even you do your practice, general local practice in the court, your CPC CRPC would be always there, but there are certain practice you will have to acquire after passing out, okay, by working with your senior and by giving your time to dealing with actual cases. So this is very important. Arup, please go ahead.
yes. So I think ABIR was also mentioning towards the beginning of this presentation about a concept called guarantee. In India, especially, you would know that a lot of companies, a lot of conglomerates have strong parentage. When I say they have a strong parentage, which means they would be backed by like a huge promoter, like a Tata or a Birla or a Dalmia or something like that. So, in which case, uh, these companies which have a very strong parentage, they will not have all of their businesses housed in a particular company. They will have special purpose vehicles which will be running these businesses. So whenever a special purpose vehicle is taking any loan, the lenders would also take a guarantee from the parent company, because most of the times the special purpose vehicle itself does not have any assets, and they will rely on the comfort which is being given by way of a guarantee from the parent company to give this loan. This is not a security in the strictest of sense, but then this is a contractual comfort which enjoys the benefit of IBC, SAFEC, everything. From an enforcement perspective. Then you have undertakings. Like I just mentioned, that a lot of big companies, they don't undertake all of their businesses through their parent company. They will create a special purpose vehicle for taxation purposes as well as to reduce their risk. So in such a circumstance, whenever the lender is giving any kind of loan to an SPV, which is basically, which does not even sometimes have any employees in it, they would take certain undertakings. Like for instance, this undertaking could be a undertaking from the parent company, which will say that if the SPV, the special purpose vehicle, is running out of money for any reason whatsoever, then the parent company will fund the SPV. So this is not a guarantee again, this is again not a security, but this is a contractual comfort which is generally taken by the lenders, basis the strong parentage of a particular borrower group. So these are the typical financing documents that you see in modern day financing transactions.
Correct. One more
Yes.
important aspect for all of you. You would be wondering what is the difference between a guarantee and undertaking. In guarantee also, I am saying that someone is going to pay off the debt. Parent can also guarantee. In undertaking also, parent is, parent company is undertaking to pay. Then what is the difference? Why there are two documents? There is a distinction between, very thin line of distinction between guarantee and undertaking, under the contract and generally. So what happens, and basically what you as a lawyer should be aware, because law is an evolving practice, correct? So there is insolvency and bankruptcy code has come. So always try and read up, because post a new law is coming, no, there are a lot of changes happen within the system. So you should be very adaptive towards that thing. Otherwise, in the entire thing, you would be missing out. Okay. So what happens in case of a guarantee, no, there is basically, it would come when some company would give a guarantee, it would come in their balance sheet, because it is taken as a liability, contingent liability under their balance sheet, and it would show. But if undertaking is given not as a guarantee, then it would not show in their balance sheet. That is important aspect, please remember. Okay. Also, undertaking is basically undertake to pay upon happening of certain event. Guarantee is always unconditional, irrevocable, and it has to be payable at the instances of other party on happening of some contingent event. Now, in case of undertaking, if there is a failure, then you have a right under Specific Relief Act to go under that person, saying that you have not performed your contract, therefore under Specific Relief Act you will have to perform it. Wherein in case of a guarantee, you have multiple rights today available under the existing laws. Arup, please explain to the students the difference, each of these thing, and the rights can be exercised vis-a-vis the undertaking provider and against the guarantor.
Yes. So guarantee is a special form of contract which is covered under your Contracts Act, where you take up financial obligations on behalf of someone else. So like the word suggests, that you basically go ahead and guarantee financial obligations on behalf of someone else. And like ABIR has already mentioned, how guarantee, if a particular company is giving a guarantee, what happens is, uh, uh, hello, so what basically happens is, uh, uh, your balance sheet will also have to reflect that a particular guarantee has been given and it's a liability of sorts. And when I say that, your listed entities, which are listing in Bombay Stock Exchange or any other exchanges, whenever they give any guarantee, they will have to tell all of their shareholders, and they will have to make a public announcement of this, because this is a huge liability that is taken. And at least in the Indian context, in terms of your Indian Contracts Act, Insolvency and Bankruptcy Code, and SAFESI Act, guarantee is something which is strictly enforced. And the courts also don't go, most of the times they will not even go into the merits of the case. And if a guarantee has been given, they would just go ahead and pass an order for invocation of the guarantee. But undertakings is not as strictly governed as a guarantee. And this is again the reason why you have undertakings, is because most of these companies which have a very strong parentage and they wouldn't want to make disclosures to their own shareholders, or they do not want to have any liabilities on their balance sheet, they will prefer to give a undertaking instead of a deed of guarantee. Because guarantee, like I said, there has to be statutory filings, you have to make statutory disclosures, and typically in a share market scenario also, you would be also aware, if any one of you is trading online, that whenever a disclosure is made by a particular listed entity that they have guaranteed obligations on behalf of someone else, so their shares, they start losing a little bit of value, because it becomes a risk for the investors as well. So whenever a guarantee is given by a listed entity, it just becomes a major liability for the owners of the company also, because they quite literally lose money whenever they make a disclosure in the stock exchange. But with undertakings is something that you do not have to disclose to anyone. You can just go ahead and give this an undertaking. So undertakings can be of both financial nature as well as non-financial nature. For instance, like I said, for SPVs which do not even have employees, the lender could say that the parent company should provide all kinds of technical expertise to a particular borrower, because without giving those technical expertise of the borrower's business will fail. So in which case, the parent company will come and say that, yes, I will undertake that the technical expertise is being provided. So for enforcing an undertaking, you can enforce it like a typical contract in terms of your specific relief act with your civil courts. But then for guarantee, you have special tribunals as well, like DRT, where you can go ahead and enforce your take a DRT action for the guarantee provided. So these are the few.
One interesting thing to the students, as Aroop stated, that there are listed companies and they are not ready to do the pledge. So sometimes what happens, there are NDU, non-disposal undertaking. So when they cannot do the pledge, we the lenders take a non-disposal undertaking, that without my permission you cannot dispose of the shares. So that is again a contractual undertaking, though not in the form of pledge, but I am restricting. So that is one of the documents. So there are various type of document, like NDU and POA. Then there is a no lien letter. So these are basically forming the basis of any financing transaction.
Yes. We'll just move on to the next slide.
So this is very important aspect. See, we as a lawyer, when we represent a bank, or suppose we are representing a borrower, our responsibility is to guide the lender or the borrower that whatever funding they are doing, those are within the realm of the law, within the four corners of the law, correct? Whatever actions. So for example, for individual, no actions are required, so long as the person is sane, so long as the person is able to do the contract, and basically whatever required under the contract act for an individual to perform. But for company, there are multiple requirements. For listed, unlisted, private, public companies, there are multiple things to be done under the Indian Companies Act, as well as in other statutes. So basically, we as a lawyer, we always look at, from the lender's perspective, whether those authorizations are in place or not. If tomorrow those authorizations are not in place, then it's basically a problematic situation. Like I would tell you, there was one instance where one of the bank has given some money to one company. At the time of giving the money, they had not checked their memorandum and articles of the association, which is called the skeleton of the company. In that, there were no borrowing power. Now, unless a company is having a borrowing power, how they can borrow money? So therefore, we as a lawyer, we look at the memorandum and articles, whether the proper resolutions are being passed for a company, and whether all the authorizations are in place. When we say authorization, it is not only the resolutions under the Companies Act, it is certain other aspect like 281 of Income Tax Act. What does it say? So in any country, basically there is a principle called crown debt. What is crown debt? Crown debt means the payment you have to make to the statutory authorities, correct? Statutory authority payment always get priority over any other payment. Now to avoid that the borrower, if there are unpaid statutory dues, then that means my loan will become subordinate to that unpaid statutory dues. Therefore, to avoid such situation, there is a concept called taking an approval under 281(1)(2) of the Income Tax Act. Similarly, there are multiple resolutions which are to be given by the company, borrowing company, guarantor, undertaking provider, personal guarantor, like some KYC documents, multiple things. Now AROOP will take you through each of these, authorizations required under these basic heads given, because they can borrow under the Indian scenario, and what all things are required, so that you are also mindful that when someone is taking loan, then these are the things, basic things are required under law.
Yes, I think ABIR has wonderfully laid down the basis for this. So I'll just run you quickly because I think we've already overshot the time. So for companies, whenever you're looking at corporate authorizations, like ABIR had already mentioned, you need to look at the constitutional documents, the documents which have constituted a company, which is the memorandum of association and articles of association. So over there, you basically go ahead and check whether the company has authorized borrowing any, like taking any loan or not, whether the company is authorized to create any kind of security on its assets or not. And these are typically the things that you also look at. And from a pledge perspective also, you need to see whether the transfer of shares can be done freely or not. So this is first authorization from the perspective of the constitutional documents. But then to undertake a particular act, a specific act, you also need to take a resolution of a board of directors in terms of your section 179 of the Companies Act. And you also, whenever you're giving any kind of security or you're giving guarantee, you also need to pass a resolution from your shareholders of the company under section 185 or 186 and section 180 as well. So these are the typical authorizations that you would be looking from a company's perspective. LLP is limited liability partnership, which is something which is a concept which was missing in India for the longest time. And in 2008, we finally had a limited liability partnership act. And in a limited liability partnership act, you need to take the resolution of both the designated partners as well as all the partners of that particular LLP. So the reason why we do it is because the LLP Act itself does not make a distinction between the kind of resolution that needs to be passed for undertaking a borrowing or a security creation transaction, which is why, just to be safe, we take a resolution from both the persons, which is the partners as well as designated partners. Again, when I speak about any kind of corporate entities, including LLP, company, or partnership, you always, or even trust, you will always have to look at the constitutional document, because if the constitutional document says that you cannot take loans, then the entity itself cannot take loans. So that's on the partnership, and that's on LLP. Individuals is just people like you and I. So for individuals, we don't have any authorizations as long as they're meeting the criteria under Indian Contracts Act of being able to contract a particular, to be able to contract into agreements. So as long as they're meeting those few conditions, which is sanity, and that person should not be a undischarged insolvent, or should not be a convict, or should not be of insane mind. As long as individuals are meeting all of these criteria, they will be able to execute any documents. For partnership, again, you need to take a resolution from all the partners, and as you would be already aware, that partnership does not have any distinction made between a designated partner or a normal partner as per the LLP Act. Hindu undivided families are again families which take up loans, and for this you need to take a consent of the karta, which is the head of the family. Proprietorship, again, like individuals, as long as they're in a position to contract in terms of your Indian Contracts Act, they should be able to execute documents. But sometimes even proprietorships have their own constitutional documents, and that's something that you will have to look at. Trust is again where something you will have to look at the constitutional documents, and then you will also have to look at you will have to take the resolution from the beneficiary as well as the manager of a particular trust.
Yeah. So one important aspect, remember trust. You all would know a company called Tata, and Tata, the main company, is a trust. Okay. Now, what is the reason of having trust? Because the liability is not to any individual. Okay. Because in a trust, there are beneficiaries. Okay. So, lot of large corporates are nowadays having the trust concept, basically to basically disassociate them from the possible insolvency, possible litigations and all. There are formation of trust. Okay. Also, one of the important thing you all should know, bank has a concept called KYC, which is know your customer. Under KYC also, banks typically do lot of checks and balances before giving any borrowing. So that is also one of the important aspect of authorizations, though are not under law. Each banks having their own system of KYC, okay, depending on their management. Now comes to the next slide, which is very important from the perspective of students. And I must tell you one thing, as a banking finance lawyer, it's been a very enriching experience for us, because as a banking finance lawyer, no, we deal with multiple sort of law, multiple. Like for a criminal lawyer, it is restricted to CRPC, IPC, and certain other, act. But for a banking finance lawyer, there are various acts, various rules and regulation, banking finance as well as project finance. And our senior Amit is also here. He would also agree that there are multiple laws involved, which makes you basically a complete lawyer sort of a thing. Okay. Now, what are the acts? One we have already discussed and explained to you. One is the Companies Act, correct? Earlier, there was Companies Act 1956. In 2013, a new Companies Act came, and there have been a lot of changes, but mostly it is overall, it's the similar structure. So, Companies Act you need to be aware of. Why? We discussed about resolution, authorization, competency, entering into contract, all these agreements. When you enter, there are basic things like all the ingredient of contract should be there. So those all are governed by the Companies Act and the Indian Contract Act. These are the two major things. Then comes to your Transfer of Property Act. As we discussed, the security interest, mortgage, charges, pledge, everything, those all would get covered under your Transfer of Property Act. Then Income Tax Act, we have already explained to you the Crown Debt 281 and all these things. So those are income tax. Then foreign exchange. Foreign exchange FEMA would come in case of overseas, outside borrowing. Correct? If someone is borrowing from outside, then there is a FEMA as well as external commercial borrowing regulations. In addition to that, there are multiple RBI circulars. Okay. One of the circular is borrowing and lending by the banks. Another circular is guarantee circular. Another circular is income recognition asset classification, how lenders would do. Another circular is June 7 stress asset circular, how banks will deal with stress asset. So RBI from time and again have been advising banks and NBFCs and financial institutions how to deal with their loan book, how to deal with the borrowing. So those regulations are also important as a banking finance lawyers to understand. And I will tell you all, like the way, you put in an alert. Suppose right now IPL is going. So you subscribe to IPL alert, any wicket falls down, you get to know. Similarly, if RBI is coming up with any circular, no, you can always do that thing. Immediately you'll get to know. These are basically your own improvement. Remember, so whatever subject you like, go. There are live laws, there are other, online things, digital, which were not there in our time. And subscribe to those alerts. And as and when those alerts would come, go through those updates, which will make you different from other lawyers. You would be more knowledgeable, you would be more accurate in your advices. Okay, and there is no seniority, juniority, starting the profession, end of the profession. We all are professional here. We'll have to work till our death. Correct? There is no retirement for lawyers. Okay, so therefore this is something you all should do. So that this is RBI regulation. Then there are multiple sectoral laws, like when you're dealing with a power project, you'll have to deal with Electricity Act. When you're dealing with port, there are multiple ports in Kerala, correct? So there are Ports Act, you'll have to deal with those acts, major port, minor port, various things. Whenever new amendments are coming, you have to be aware of this. And there are related rules, regulation, and circular. Sorry, there are two things we forgot to mention here. One is IBC, Insolvency and Bankruptcy Code, which is also very important, subject, and you all should be reading and be updated about it. If you would like to be a banking finance lawyer, or generally. Another is Negotiable Instrument Act. So these are basic things. At this stage, as a student, you should be reading and understanding the basic foundation. Remember one thing, law is a logic. Mostly law is a logic, and it is based on various statutes and rules and regulation. So long as you are able to put in your logic within those four corners of rules and regulation, you are done. You would become a very good lawyer. You don't have to do anything illegal or anything misleading or anything. But so long as you have the analytical skill to put your legal logic into the four corners of acts and rules and regulations, you would be able to deal with multiple complex things. There are instances where there are issues comes to us where there are no precedent. So we do analyze the issues, we do discuss with the peers, and then we start coming out of, sort of, solutions to it. So you being a lawyer, you remember that there are everything, there has to be some logic to it, so that in the court, judges will be able to appreciate you better if it's an evolving law. In the corporate, you will be able to better tell your clients, be it bank or be it borrower, be it M&A transaction, wherever, you will be able to, explain to your clients better way. Arup, am I missing anything in this decoding of law? You can please add on to it if I'm missing something, and then we can go to the question answer session. We have already exceeded the timeline, I think.
Yes.
Sorry
Yes.
to keep you this thing, but we needed to cover all these things.
Not an issue, sir. We have enough time. No problem.
Okay.
Yes.
Arup,
No, I think you've already spoken extensively on decoding of laws. Obviously, there are sectoral laws that if we sit on it, it can probably become a certificate course for a year. So we wouldn't be sitting here for a year. Like, at least on the periphery, that's what ABIR has already spoken about. And if you would want to if you have interest in this particular field, and I think you should be reading all of these acts from a banking perspective, and yeah, you can take it forward that way.
Yeah. So we are happy to, sort of response to any questions or anything from the students or from the faculty. Happy to take it forward.
Yes, sir. So everyone, all participants, kindly listen. I humbly request all of you to raise your hands. There is an option to raise your hand. After that, I will kindly introduce yourself first, then ask the question. Now, since there are students from Project Complete Lawyer as well as from outside, I think we can give priority to students within Project Complete Lawyer, and then we will have, if there are questions from outsiders as well, we will also try to entertain. So we are planning to have a 15-minute Q&A session, and if necessary, we will also extend the time if necessary. So the floor is open for Q&A. Any questions, anyone? Please raise your hands first. The option is there in the Google Meet. So you can raise your questions. Anyone? Hello? If you're unable to find the
One question.
yeah.
You were mentioning about a consortium of banks coming together for funding a project, and you were also mentioning about a trustee agreement. And what will be the nature of that particular agreement? Will it suppose there are multiple banks coming forward funding? Some banks will be funding higher amounts, and who will be what will be the nature of that particular agreement?
So what happens? Very good question actually. So, trustee mechanism is a dichotomy relationship between a trustee and the lenders. What happens if there are multiple lenders? Creating security for each multiple lender would be a taxing thing, correct? You'll have to pay stamp duty for each of this transaction, each of the mortgage deed, correct? Not only that, if tomorrow lender would like to novate or transfer the loan to another lender, then again you'll have to enter into a new document, correct? So having this issue, this trustee mechanism has come. What is trustee mechanism? There are suppose 5 lenders, and 5 lenders are funding in a consortium to one borrower only. So the 5 lender will ask the borrower to appoint a trustee and basically vest the trust property in favor of the trustee. What is the trust property? Trust property are all those securities which are to be created in favor of the borrower, correct? So there would be a declaration of trust, and under the declaration, borrower will make a declaration of the trust, and the trustee will become the owner, or basically basically having the control over the trust property, and all the lender would become beneficiary. Now if there is a change in beneficiary, the exact stance of trustee is not changing. Security is created in favor of trustee. So tomorrow if SBI transfer the loan to Catholic Syrian Bank, Catholic Syrian Bank would become a trustee, beneficiary to the trust, but trustee will remain the actual beneficiary of the security, and the interest would be with the lenders. So this basically resolves 2 purposes. One is in case of any inter se change of lender, there are no sort of issue. Second, this would reduce the stamp duty incidences. And the entire trustee agreement, basically it is dealing with how the trustee would act as per the instruction of the bank, what are the rights, duties, obligation of the trustee. All these things would be part of the trustee agreement.
And this trustee may be a representative of all these banks, or will it be, what will be the nature of the constitution?
So trustee basically hold the security for the benefit of the lender. Basically,
what will be the nature of the what is it a company or somebody, some
no, so there are specialized trustee companies like IDBI Trusteeship Limited, SBI Cap Trusteeship Limited, Catalyst Trusteeship. They have been formed for that purposes only, basically to deal with this. Amit, do you have anything to add on this?
No, nothing. But Johnson sir, the thing is that see, in some consortium, we'll be having around 40 plus lawyers. Sorry, 40 plus banks involved in a consortium. So 40, even 45 in Alok Industries, we had around 40 lenders coming in to fund a particular borrower. So the thing is that see, creation of security in favor of each lender is it's not possible. Practically, it is not possible. So what we do, we, as ABIR has said, we appoint a trustee. A trustee will be there, and all the securities will be created in favor of the trustee. Okay, sir. And whenever there is a default, the lenders actually instruct the trustee to enforce the security, and the security trustee will be enforcing the security. See, is taking possession, selling, everything will be done by the trustee, and the sharing will be done in proportion to the exposure of the lender. So the lender having maximum exposure will get the money according to his exposure, proportional to his exposure. So this is in large value corporate funding. Most of the cases, trustees involved.
Yeah, for general day-to-day funding, trustee is not required. Trustee is a very specialized, project finance, banking finance sort of a product. There are security agent also, Mr. Johnson. So basically, when you don't find a trustee, you can appoint a security agent, and then security agent can hold the security.
Thank you, sir. It's very clear. Thank you, Amit. Thank you.
So we have
Yeah.
we have a question from Ransi, I believe. Ransi, you can unmute and introduce yourself first and ask the question.
Yes, Aravind, if you can mute and ask.
Yeah, good evening, dignitaries. I'm Arvind Prakash from School of Legal Studies, currently doing fourth year of BCom LLB. So my doubt is that do we have anything called as a digital banking license available in India? And also, can you just throw some light on the legality and the regulatory aspect of neobanks?
AROOP?
So the RBI has very recently come up with regulations on this, and there are a lot of startups who have started operating in this particular space. You must have come across all these advertisements by Navi, India Bulls, Dhani app. So while it is comparatively a new concept to the industry, but then there are like a lot of players which have started playing in that, and it's a very legal setup. And I think ABIR and I would also help Bank of Baroda set up one of their digital banking platforms. And we've done an extensive research on moving everything online, including documentation and how things can be done on an online basis without any person having to come to the bank. So yes, there are existing regulations which are in place which does allow for all of these transactions, and these are also considered as banking activities now.
But one thing to remember, we have Arvind. Sorry, I interrupted you. But one thing to remember, what we could do is with respect to unsecured loan, because for secured loan, no, there are certain requirements like power of attorney has to be notarized, which cannot be done online. So certain things we had to do hybrid. But for Bank of Baroda, what we did, certain products we have fully done digitalization. It can be done digitally.
And
So, yeah,
your
Arvind,
information technology.
Arvind, no, go ahead, Aru.
Yeah, sure.
No.
But taking the business facet of the neobanks, do you think the Indian banking scenario is ready for it?
I think Indian banks have been evolving every now and then, and like you see, the Indian banks, I think Indian banks have built around a very successful and a comprehensive ecosystem around here, because like a lot of countries which started out with us, lot of their banking systems have failed multiple times, and Reserve Bank of India has done a brilliant job uh, regulating these banks while also giving them enough flexibility to undertake new ventures like the one that you're just talking about. And the banks have been pretty open to taking up these challenges. Like, for instance, Bank of Baroda also was it's a 100-year-old organization, but they were quite open about it. And they have implemented something very successfully. So I think Indian market is always eager to learn, and they have shown it time and again that they have built up a very robust business ecosystem, and which is why you don't see a lot of banks failing in India as well, which is a very common occurrence outside.
Yeah. Also, one more thing. Recently, RBI has come out that ATM withdrawal also you can do digitally. Correct? You don't have to. You can do with QR code. So the law is evolving. That's what I said in the beginning and during this thing, during the ending of this thing, that as a banking finance lawyer, no, it is very challenging for us, but very enriching experience for us, because it is a very evolving sector. Every day we need to be updated or various things.
Imagine something as basic as insolvency. We've had so many regulations from time and again. Like, ultimately, the latest insolvency regulation, the legislation is from 2016, which is only, I think, 6 years ago. And especially things around insolvency, they move really fast. And I don't think for Indian players to catch up is a problem, because everyone's quite eager into getting into new markets.
Thank you, sir.
Okay, next person is Renju. Renju, you can unmute yourself and kindly introduce before asking the question.
So myself Renju, I am a participant of Project Complete Lawyer. Nowadays the banking and other financial institutions rising day by day. So there must be also security breaches is one of the issue that is faced by them. So is there any specific law for safeguarding the interest of them?
So there are multiple law, Renju. One is, that's a very good question. So earlier there used to be recovery of debt dues to banks and financial institutions. That is one. Second is SARF-C. And then now IBC has come into effect. So having all these laws in place, banks are able to manage, the recovery of debt in case of a default. Also, there are options given to bank by RBI where banks can restructure their loan rather than enforcing the security. So, for example, June 7 restructuring circular is also there by RBI, wherein banks can restructure the loan rather than enforcing it. So there are multiple mechanisms available under the current Indian system, wherein bank can enforce, recover, or restructure the debt in case of an event of default.
And Renju, generally also, this has been proven worldwide that banking and finance institutions are someone who actually run a country, regardless of what the political scenario is, because these guys have the money and they have a very strong lobby with the legislators as well. So at least in India as a jurisdiction has very stringent laws around banking and recovery of dues from the by the lenders from the borrower. So regulation wise, I think whatever we dealt in part 5 of our presentation, there are absolutely a lot of robust legislation in place. And it's not that the Indian legislation has stopped right there. They have been legislating new regulations, new laws every day. Like, if you just go to RBI's notification page, you would figure out that RBI has been evolving every day. They have some sort of a notification that they think can be better for the banks. They come out with those.
Also, you all would be wondering why HDFC merged with HDFC Bank. Parent merged with a subsidiary. Do you know why? Because RBI has made it very stringent for NBFCs to run, which is bank-like compliances. So HDFC said, if I have to comply like a bank, might as well merge with the bank and make it a bigger organization. So that is how the bank NBFCs are merging with bank wherever there are possibilities. But that possibility may not be there for Bajaj Finance or someone, because they don't have a bank per se. So they will have to also do the stringent compliances under the new AIRA guidelines. So as Aroop said, that RBI is monitoring the entire situation very, very closely. During pandemic also they came up with a lot of various things which basically kept the business and economy running. So this is going to happen. It's a continuous evolving process.
And I think personally, these are my personal views. Reserve Bank of India, in my view, is one of the best instrumentality of the government, because they have been so proactive. Like even during the 2008 recession, all of the countries were affected, but we managed it really well. And even though, as like a law student who used to get confused with so many circulars during my internships, I did not like Reserve Bank of India for being so confusing. But then over the years, I have built that maturity and have figured out that Reserve Bank of India is actually doing one of the best jobs around the world. And which is why you don't see a lot of banks fail. We have seen a lot of banks fail, but it is nothing in comparison to everywhere else outside.
There is one question by Renji Matthew.
Renzi Matthew, I believe.
Can you now?
Yeah. Renzi, can you unmute yourself and kindly introduce and ask the question? Renzi? I think he has raised the question in the chat box itself. And I believe he is facing some technical issue. I will read out the question. My question is, how can NPA risk are avoided in unsecured loans, including credit from microfinance institutions? That is the question.
Very, very good question. For unsecured loan, NPA risk is always there. It's a credit call by the bank that without any security, they are going ahead, basis the business, basis the status of the borrower, and basis the ability to pay from its own cash resources. So these are basically a commercial call, but when there are unsecured loans happens, we have done also documentation for unsecured loans. There are multiple things which banks would try to implement to safeguard their interest. And also one more aspect is that under IBC, unsecured, secured, it's the same parity in case of liquidation. Okay, though secured lender would get some sort of benefit, that is a jurisprudential thing, but IBC section 53 code does not distinguish between secured and unsecured creditor. And in fact, unsecured creditor nowadays can resort to IBC, which was not possible under Saraf. So therefore, this under IBC, these risks are mitigated to a great extent. Amit, you'd like to add something on this? If I would have missed out anything.
Yeah, only one thing is a commercial thing, that is a rating. Basically, the unsecured loans are given in high value loans only to highly rated companies like the Tata or a Mahindra or a HDFC Bank. So where the commercial guys are pretty much clear that there cannot be any default because of the financial strength of the borrower. So only in such cases like a Tata or I said HDFC Bank, we give a unsecured loan. So it's basically, as Abir said, it's a credit call only.
Thank you, Amit sir, ABIR sir, for the response. Now, I believe a few of you are also finding it difficult to raise your hands. There may be some technical difficulty. Okay, thank you so much. Renzi has conveyed his gratitude. Then, any more questions, anyone? You can unmute yourself and raise the question.
I have a question to, I think I can ask it to Amit, because we have instances where these deposit of title deeds happen. And can this deposit of title deeds be done with respect to securing a loan given by an individual, or is there any restriction for that? Like it can be only with a financial institution, or should it be? Can it be done in other individuals or
So
somebody?
just to reiterate your question, that one individual is giving loan to another individual, whether title deeds can be secured or not, correct?
Yeah, deposit of title
Correct.
deed.
Deposit can happen or not. I think that is possible. There could be, like, if I am giving loan to you, you can definitely create security in my favor by depositing the title deeds. There are no restrictions under the Transfer of Property Act that it has to happen with the banks and financial institution only.
But the only issue would be, I think, from an enforcement perspective, where your DRT and all of those routes will not be available.
Correct.
You can still go ahead and sue them, but then going through DRT, because for
that would be under your civil court.
Yes, yes.
Amit?
But
yeah, I think that is correct because there is no restriction in the TP Act.
Thank you.
And see, sir, I just want to ask a question to ABIR, which is not exactly connected to the banking finance. For all the see, Kerala is a place where we don't have much exposure to these kind of transactions or lendings or all banking finance basically. So how can a person who is aspiring to become a banking finance lawyer or a person to become a part of a tier 1, tier 2 law firm, what should we do? What are the steps we have to take to achieve that? If you can throw some light on it, it would be helpful for the students.
Sure. Myself and AROOP would definitely put a light on it. But basically within Kerala, or someone can go outside Kerala and explore, because within Kerala there are not many financial institution, registered office of bank, and financial activities are happening. So remotely it may not be done, but if someone would be able to move to Bombay, Delhi, or cities where things are happening, Bangalore, then it may be possible. I'm just trying to understand your question, then I will answer accordingly.
No, I was just asking. There is what do you call, some law firms have identified some law colleges, right, from where they will be taking their associates.
Okay, got it. I will give you a live example. Got it, Amit. So I myself passed out from a college, and AROOP also, where neither tier 1 law firm, none of the law firm would have come for the campus placement. Let me tell you. Okay. So if someone would like to be, aspire to be a banking finance lawyer and would like to work in a tier 1 law firm, the best possible thing is to do is that, first of all, prepare yourself the way we have guided you today on this session, and we would love to take another session if required, and we would love to help all of you again. In addition to that, do internships during your college days. Don't think that you will not be able to secure internship. You will have to push for this thing, and don't try for tier 1 or anything. Try for any other law firm. See, learning can happen anywhere. You need to you need to work anywhere. So when I passed out, I never got recruited into Amarchand. Let me be very frank. I worked 4 years in a tier 2 or tier 3 law firm. I learned the tricks, I learned the trade, and then Amarchand came to me and recruited me. That is how it happened. So if you have the zeal of learning, if you have that ability to do things, you need to have some patience. Remember that not everyone they can accommodate, but once you become sort of having knowledge about the subject, you would be able to get into where you would like to reach. But for some, it happens because they are just from national law school and it is happening. But you just being in Kerala doesn't mean no one is inferior. What I'm trying to say, just because of the college, it is about individual ability, how you are dealing your circumstances and how you are overcoming your circumstances. I never felt bad when Amarchan didn't take me from the college. There were no placement for us. Okay, I went on my own to the law firm. I got recruited. It was a very small salary. I worked hard there. I learned the work, and that's how slowly I have grown where I am after 16, 17 years. But don't look at the success. When Sachin Tendulkar is playing, remember, before coming to the pitch, he is been practicing hours and hours in the background. And there are a lot of other things you have to sacrifice. So I think, Amit, the best way to do it, if someone would really want to do it, they should do the internship. They should wherever they get a chance, join there and learn the skills, and then take proper mentorship from you all, from us, and then grow in life. That is the only thing, because college won't define anyone.
College only helps you with your first job.
First job.
That's it.
Maybe, but after that, it is your individual ability. I have seen a lot of national law school students, they're not doing well after some point of time. But there are non-national law school like Cochin, I think Nual's Kochi.
Nual's Kochi.
They're really good. I have worked with them. There are normal colleges. Amit, it's been a pleasure working with him. He is one of the best legal project finance lawyer we have presently in Bombay. He has a sound, legal logic and knowledge to it, though he has not studied it. So there is nothing called, that because I am from Kerala, because I am from West Bengal, because he is from Odisha, there are no opportunities. No, it is not. We have to create the opportunity for ourselves. We can definitely do so. If we can do it, you all can do it. All the students can do it. And after this pandemic, everything is digital. You can do digital internship nowadays. You don't have to travel. You have to be aware of the opportunities around you. You have to join wherever you get a chance, prove your mettle, and then prove yourself. Just because your college is not able to give you job, don't get disheartened. You try on your own. We have tried on our own and got in here. Both for me and Aroop. Aroop, that is correct, right?
Yes, so my college also did not have any placements. I think the only place that I got through was Surana and Surana in Chennai. Although I did not take up that offer, I went with Link Legal. But I also did not have a tier 1 job out of the college. And honestly, college, I would suggest not to get bogged down by the prejudices that's against any college or something, because the college only, trust me, it only helps you with your first job. It doesn't even help you through your probation period, because there are like a lot of endless IO people that I've seen who have not made it through probation as well. So it just helps you with your first job. Everything is on you after that. It's the same thing. Like when we were giving our 10th examination, we used to think it's the world to us. But right now it's just a birth certificate for you. So similarly, so college doesn't matter. Actually, all tier 1 law firms are headed by non-national law school students. So from that perspective, it's entirely on you.
Yeah, and also there are a lot of avenues today. When I passed out, the only 2 avenues were law firm. Very few selected law firms were there, or corporate jobs. Very few corporate used to take. Nowadays, the legal field has evolved. vastly increased. There are multiple opportunities. So I think, as AROOP correctly pointed out, it's just the first job, but you can create your own, career graph. College doesn't matter.
Yes, sir. Very valuable information that you have just shared with us. Especially, I have very briefly mentioned to, I believe, ABIR sir already. Project Complete Lawyer, all of the Project Complete Lawyer students are first generation lawyers, and all of them are from non-national law schools. And
Also, just to be a little more comfort to you, maybe, the founding partner of our firm is a first generation lawyer from a non-national law school. He's from Campus Law, Delhi. And look at him today. He has a firm in the tier 1 practice area. So yeah, it's honestly nothing. Like college means nothing.
very valuable information and inspirational indeed.
But college, you do need to study in college. That's something that I would really like to add on. Because things that you get to study in college, you will not, no one will have that much of patience in your profession to teach you all of these things. So college is a very important part of my life. I would say that at least.
Yeah. I have also studied quite hard, and it was difficult. And to be very frank, we used to study very hard together, all my batchmates or my roommates, and those things are helping me today, because those studies, those basic foundation things are very important.
Yes, and once you join the profession, no one's going to handhold you to teach you all of that. That's only your professors, which I'm very grateful to all of my professors, because if not for them, I would not have picked up the interpretation skill that I have today.
Thank you, ABIR sir and AROOP. I think, is there any other questions that the participants would like to ask? One last question. We have exceeded our time, nevertheless. Any last questions from the side of the participants? So one question that I would like to ask, something that struck my mind, that is, you spoke about external commercial borrowing, ABIR sir. Both of you have spoken about it. And you have mentioned that the reason why external commercial borrowing are made is because they are cheaper. How the external commercial borrowings are made cheaper compared to the domestic ones? And how is the danger to our national security? Is there any danger as such when external borrowings are increased as such?
So, yes. So whenever you go to a bank, so first of all, I would ask you a question. Whenever you go to a bank and you put things in fixed deposit, what is the interest rate that you've generally seen that the lenders, Indian banks give you in the neighborhood of how much?
It averages between 2% and 6%, I believe.
Averages 2% to 6%, right? So in foreign countries, because bank is an established organization, most of the foreign countries, they give you 0%, and some of them, they even charge you in some amount of fee to have your money safeguarded with them. So because the deposit for the banks outside is cheaper, because unlike Indian banks where you actually have to pay interest to your depositors, a lot of foreign banks, they don't pay any interest to their depositors. So for them, borrowing for them is cheaper, which is why they can pass on the direct benefit in terms of cheaper interest rate to the direct customers, which is the borrower. That is how they reach all of those better interest rate. And from a security perspective, as you have rightly pointed out, that's something that's Reserve Bank of India, given how Reserve Bank of India is on top of everything. ECB is a very strictly regulated process, because Reserve Bank of India does not want Indian money to travel offshores, because that's a big problem for a country, because that's when your your currency starts losing value and you don't have any foreign exchange. So which is why whenever you see that ECB master direction, you would see that it's a very narrow window as to under what circumstances can you borrow from who. the ECB also defines as to who can you borrow from, which sector can borrow, what will be the maturity, like the loan amount, what will be the kind of security that can be given. It's a very strictly governed thing. It's the only motivation for borrowers to go outside is for cheap credit. And that's also because the government of India is aware that few of our sectors require cheap credit, which may not be made possible in India because Indian lenders have a lot of cost by way of interest that they have to pay to their depositors, which is why few of the sectors they've allowed. And they've also restricted the end use of the ECB loans. Like if you raise a loan from Indian banks, you can use it for whatever purpose, right? Whichever is defined. And there's a huge number of items for which you can use it. But for ECB, it is very restricted. There are only 5-6 identified end use which can be in which those money can be applied for.
Understood.
Also, there used to be round tripping. Used to be a concept called round tripping. Okay, what used to happen? Money used to go outside and it used to come back. But now all these things have been regulated by Reserve Bank of India as well as banks. There are, checks and balances. National security per se, there is no issue, so long as they are not entering into our banking sector and they are not taking over key assets. So basically there are restrictions on FDIs and all on key sectors, but now with this present government there is a lot of liberalizations and those sort of restrictions are gone. So technically, it's now sort of a open thing, but there are still restrictions. Like earlier, it used to be telecommunication, defense sector, and all. Those are now relaxed a bit.
And I think Ransi had asked one final question on that text message on the Money Lenders Act. I was just looking it up. Money Lenders Act is very state specific. It's not like a central legislation, and each of these states have come up with Money Lenders Act themselves. So yes, they would be required to be registered, but it's not a central law. So most of the states where most of your lending transactions happen, it does not happen, because we have seen like a lot of inter-corporate loans where all kinds of security is taken, but both the lender and the borrower would not be registered under the Money Lenders Act.
So these are called usurious law.
Yes.
Law. And basically, as AROOP is saying, so usurious loans related regulations are there, but these are state specific. Yes.
So I think we can wind up the session now. Thank you, ABIR sir. Thank you, AROOP sir. Thank you so much for spending your time with us and helping us explore a new area of legal practice that is not the students are not aware of, especially as Amit sir has mentioned, especially if students from Kerala, they are not much explored as of yet, and it's not.
By the way, just to add on to that, I would also say that banking finance is one of the biggest sector when it comes to corporate law, because not only Indian law firms like Shardul Amachan Mangaldas, Cyril Amachan Mangaldas, our firm, most of our firms are mostly finance law firms, including the biggest ones in the country and outside as well. Like if you look at Allen & Overy, White & Case, they have about 30% of their practice area as banking finance. So it is a very important sector. And wherever there's money involved, a lot of it will also trickle down to the lawyers. So from that perspective, it's a very important sector.
And there is a lot of shortage for a good banking finance lawyer. Let me tell you, there is a lot of shortage because it's a very labor intensive work. We work during quarter end endlessly. And it is just love of the subject, we do it. Like we have also worked throughout the week. Today also we are working, but it is just the love of the subject. We don't get tired. So if someone loves what they want to do, I think they would achieve whatever they want to do. So yeah, banking finance is one of the important thing which students can definitely look for.
ABIR sir is also a guest faculty member at Jawaharlal Nehru Banking and Institute of Banking and Finance. And I can see that it is reflected in his presentation. It's very difficult to strike a balance between a faculty and a practitioner. And also we have, I have seen another person, that is Johnson Gomez sir. He has been, who is the chairperson of Project Complete Lawyer. Just mentioning, very rare achievement indeed. Again, as a convener of Project Complete Lawyer, I would like to thank ABIR sir and AROOP sir for spending their time with us and helping the participants to explore the area of banking and finance, and a very big wide area, a multidisciplinary area involving multiple legislations, multiple entities, including individuals, companies, limited liability partnerships, that is multiple artificial persons. A very wide and very lucrative and an area which has a lot of scope. Thank you, sir, for thank you both for coming here and enlightening the students, motivating them to become successful legal practitioners. I also thank Johnson Gomez sir, Safi Mohan sir, Amit sir, and other members of Law and Justice Research Foundation and Cochin Institute of International Arbitration, who has been here and aiding us in organizing this event. Thank you all. Thank you to all the participants. Thank you for the questions that has been raised. Okay. Good night, everyone.